Welcome back to my channel. I'm the Storytellawyer. I'm a lawyer and storyteller. I share real-life legal case stories to show that legal knowledge is fun and essential for everyone. You can find additional details of this legal case in the description below. Click share, like, and subscribe button for fascinating legal stories and updates. The content in this video is meant for educational and entertainment purposes and not intended to provide legal advice of any kind. Storytellawyer will not be liable for actions taken based on the content provided on this video. Today we're going to explore an interesting legal case of a will left behind for friends and family members. Inheritance disputes are more than just legal battles, they are emotionally charged conflicts. At the heart of these disputes lies a high-stakes game for financial security and family legacies. Let's assume that your friend has left an inheritance in their will, but you are not happy with the amount. Can you take it to court and claim more? While claiming more could be an option, it is important to note that the fight for inheritance can be a long and arduous journey. It often results in strained relationships and financial ruin. For those of you that are unfamiliar with what a will is a legal document that specifies how an individual's assets and affairs are to be managed following their death. It provides clear instructions regarding the distribution of property and the handling of other personal matters. Let's get started. Our story begins with Mr. Max Frederick Willis, a generous man in Australia who helped people from the Solomon Islands come to Australia to study. He opened his home and his heart to these students. Mr. Willis supported Sharon and Kim to live and get an education in Australia while he was alive. Mr. Willis provided them with financial assistance, guidance, and a supportive environment. Mr. Willis supported Sharon and Kim because he had a history of helping people from abroad obtain tertiary qualifications in Australia. He was a man with a mission who dedicated his life to helping students from abroad achieve their academic dreams. Sharon and Kim were not related to Mr. Willis by blood, but he saw them as part of his projects to assist individuals in achieving their educational and professional goals. Mr. Willis provided significant financial support and rent-free accommodation to Sharon and Kim to help them study and settle in Australia. Mr. Willis emphasized that his assistance was help but no charity or handouts, indicating a structured support system with expectations of repayment and contributions. Before Mr. Willis died, he left an inheritance for Sharon and Kim in his will. Mr. Willis included Sharon and Kim in his will by bequeathing $50,000 to Sharon for her education and forgiving their debts, showing his continued commitment to their advancement even after his death. Sharon and Kim were not happy with what they received from the will of Mr. Willis. $50,000, forgiving their debts and providing rent-free accommodation for a year were too little compared to what they wanted. They wanted up to $450,000 for their maintenance and advancement in life. Before they appealed the case to a higher court, the primary judge ruled that the provisions in the will were fair. However, Sharon and Kim were not happy with the original decision made by the primary judge. When they appealed the original decision, they argued that Mr. Willis didn't make enough provision for them. Although Sharon and Kim were not related to Mr. Willis by blood, Sharon and Kim argued that they were like family to Mr. Willis and deserved more support. They said that Mr. Willis had promised to help them settle in Australia, and that they had relied on his support for years. This is why they believed that they deserved $450,000, and not $50,000. Sharon and Kim presented evidence of their relationship with Mr. Willis. Their claims were based on the actions of Mr. Willis while he lived with them, as well as written communications such as emails and letters. The court relied on these documented arrangements and the deceased's meticulous records to assess the claims. According to the evidence, Mr. Willis provided significant financial support to Kim and Sharon, including loans and rent-free accommodation to help them study and settle in Australia. They lived at the residence of Mr. Willis and performed household tasks as part of their arrangement. Mr. Willis supported Sharon's education, including her bachelor's and master's degrees, with the expectation that she would become a teacher. Sharon and Kim's 3 children also moved to Australia and lived together with Mr. Willis, indicating a close and supportive relationship. Mr. Willis supported Sharon, Kim and their 3 children. They relied on Mr. Willis for financial support. The court had to decide if Sharon and Kim were entitled to more money under the succession law. The judges looked at whether Mr. Willis had made adequate provision for them in his will. The court found that Sharon and Kim were not eligible persons under the succession law. The court determined that there was nothing in the relationship between Mr. Willis, Sharon and Kim that made them natural objects of testamentary recognition. This meant Mr. Willis had no moral duty to provide for Sharon and Kim in his will. The court also found that before Mr. Willis passed away, the deceased had already made adequate provision for Sharon and Kim in his will, including $50,000, forgiving their debts and providing rent-free accommodation for a year. The court concluded that Sharon and Kim did not meet the criteria to ask for more. Mr. Willis had already made enough support. The court also applied an evaluative judgment, considering community standards and expectations. The Court of Appeal ultimately affirmed the decision made by the lower court. The appeal was dismissed. Sharon and Kim were ordered to pay the other party's costs of the appeal. The primary judge's findings were upheld, including that Sharon and Kim were not eligible persons under the succession law and that adequate provision had been made for them in Mr. Willis's will. Based on my experience, the legal costs of a court case and subsequent appeals, such as Court of Appeal, can amount to hundreds of thousands of dollars. If the court ordered Sharon and Kim to cover the opposing party's appeal costs, it would be financially devastating for both Kim and Sharon. Imagine what remains after settling their legal fees and those of the opposing party's lawyers. Most likely a large debt. Let me ask you questions about repeated kindness and rights. Do you think that consistent acts of consideration can lead to a sense of entitlement? How do community standards and expectations influence legal decisions? Sharon and Kim believed that they had legal grounds to ask for more. Leave comments below. Thank you for watching. Don't forget to like, share and subscribe for more insightful stories on legal cases.